Okay, good morning, everybody. My name is Lindsay Fabrizio. I am the Continuum of Care Manager with the Housing Collective here for Opening Doors Fairfield County. You guys are all here today for our client support training, which is understanding conservatorship in Connecticut. We have Katrina Camera from Schafler Camera, attorneys at law from Bridgeport, Stratford,
Shelton.
Shelton. She's here today to go over the process and sort of what it is like to go through the conservatorship process, how to get people involved, and how they can provide assistance. So just some quick housekeeping. I'm going to take this screen away so I can see you guys. Um, Anyone who is registered for the event will receive a copy of the recording because I have all of your emails listed. If for some reason you are using someone else's account and you're showing up as someone else's name, then you're likely attending through their registration. So please just pop your email in the chat for me so that way I can make sure that you're included on the list of registrants to receive the recording afterwards. Likewise, I will also be posting the recording and any associated materials to Roundtable afterwards. So if you are on that platform, you will be able to see it there as well. I think that's everything, and I'm going to turn it over to you, Katrina. Thank you so much for being here today.
Oh, you're welcome. So my name's attorney Katrina Camera, and I am a contract conservator for the state in the state of Connecticut. So what that basically means is once a client goes to court, and we'll get into that, and I become the conservator, my process starts then. So housing, of course, is the hardest thing. I'm trying to figure out if I should go step one through the application. I think I'll do that. And again, I don't present often. I just do work. I work 7 days a week. So it's going to be a little rough. I don't have anything pre-planned. I just know what I do. So you have a client who is in need of housing, and you want to get them housing and you want to maintain that housing. And I think everybody's biggest fear is when people are handling their own money, they may not pay the rent, which leads to an eviction, which leads to your job becoming impossible to find housing again. So that's the biggest thing. When I started this company, what I realized was I was a conservator, and I'm just trying to figure out how could I best help. And most of my clients are connected with DEMIS. So I've got usually a good support team, clinical. And what was happening was they were having to deal with the redeterminations for DSS, helping them pay their bills. And that really wasn't their function. Their function was really to be more clinical. So I kind of split it out. And this is where you get the voluntary conservator of the state. So everybody can do their jobs. So what we do is we look at the client, we work with the team, we will become the Social Security rep payee. We are an agency rep with Social Security. We will connect with and become recognized with DSS. So we handle all the functions, paying the bills, setting up the budget. We give our clients what's called a TrueLink card. And then once it's up and running, it just kind of goes. But your first hurdle is going to be seeing if they want a voluntary conservator of person. Voluntary means they're going to get canvassed by a judge, that they understand what it is they're doing, because they are giving up rights. Because I will, whoever is the conservator will be in charge. But we all do practice least restrictive, and we work directly with the client and the team. So in that package, your first step would be to explain to the client the process. It is, someone's going to take away your money, someone's going to pay your bills. So how do you say that in the nicest ways? You want them to be housed permanently. Now our office runs on a certain platform. We get our fiduciary certificate from the court. First thing we'll do is reach out to the client, find out who they're connected with. In your case, basically, you're looking for housing. So we're going to need the lease, the bills, and we contact, with the landlord. We will get the Social Security. It'll come direct deposit. We use Newtown Savings Bank. We order them a TrueLink card. That's how they'll get their necessity money. And it's either weekly or what, after the bills are paid, they'll get their money, like, say every Tuesday or whatever day they want it. We set the budget on auto, which means if their money comes in on the 1st, all their bills are going to get paid on the 1st. We already know the calculation by 4.3 weeks to give them weekly necessity money. And then it kind of just runs itself. In the background, what we're doing is the Social Security redeterminations, which are due, the rep payee reports. If they're SSI, we have different reporting requirements. If they're SSD, different reporting requirements. So they never have to deal with any of that and lose benefits. We do the same for DSS. We do all the redeterminations. We review if they are not getting SNAP or they are eligible for cash. We do all the work so they never lose that supportive thing. They've got their housing, they're connected with their teams, and it's least restrictive. They're not going to really see us. They're absolutely, if they want budget meetings, they want to switch the budget, or if they want to move, whatever they want to do, we're always here. We have a very large staff. I think we're at 20 and we're hiring 3 more people. So we're pretty accessible. We're broken down into divisions. The case comes to me and I look at it first. Where is it going to go? Our Social Security division, they're going to file for rep payee, and bank account is open. That all happens once the money's coming in. Boom, we're going to send it down to budget, where our initial budget is set up, and we're working on that in the interim. Everything's changed to us. Everything will get set on auto. And then from there, all the redeterminations and everything happens. So it's really an easy process once it's up and running. The hardest part is getting that first step, the conservatorship. So it's two documents that you need to file in the probate court where the person is currently residing. It must be there or your application will be kicked out. So you're going to go through, fill out every single piece of information that you know. The biggest thing I tell everybody is clients, they have to go to court. The judge will canvass them. So if they go, I have no idea why I'm here, somebody just told me to fill this out. And basically what they really need to understand is that somebody else is going to be taking their Social Security and paying their bills. So people just generally write in for conservator of the estate, budgeting and benefits. Pretty easy is what they're asking for. The thing I always tell people when it says, the notice part, it says you're supposed to give notice. If you're the one working on the application with them, put down your information as well, so you'll get notice of the hearing. People have a tendency to forget to attend the hearings. A lot of them are virtual. A lot of them, it depends on the judge and the court. Where you're going, what's your primary courts? Are you Bridgeport?
We're all over the place.
So
yeah, Bridgeport, Stanford, Norwalk, and Danbury are our primary catchment area.
Right, and I know all the judges there. So they all operate a little bit differently, but they're going to want to canvass that the client absolutely knows what they're doing. I mean, it doesn't have to be extensive, but you're giving up rights essentially, for somebody to help. The way you want to present it is, hey, you're going to be stabilized, have a roof over your head, your bills are paid, one less thing that you have to worry about. But I'd always put, somebody else so that person can remind them to go to court or take them to court. I don't know if you do that or not. A lot of my clients are afraid to go to court. It becomes intimidating. So sometimes they need that extra support, maybe just emotional support if they're willing to do this. When you get to the bottom of the application, so the petitioner is going to be your client, just so you understand that. Then where it says proposed conservator, you can leave it blank or you can put my information in. I'm not the only conservator. There's a ton of really good conservators, and a lot of us switch, will resign and have somebody else take over just because clients get tired or they want something different, and none of us really care. It's, who's going to do the best job for them, and if the client's not happy, it's voluntary.
What if the case manager or the staff person is unfamiliar with who could be a conservator for their client? Do they leave that blank and the court would appoint it, or is that
Right.
sort of?
And it kind of depends by courts, because conservators are pretty much sought out after as an attorney. There are conservators who are not attorneys. The benefit to having the attorney is we've got so much malpractice insurance. We're just by virtue of being an attorney. I'm also a contract conservator with the state of Connecticut, which I have to have another slew of insurances. And judges, of course, like to, if they have a choice, they're going to appoint an attorney over, because we're more accountable at the end of the day. But there are a lot of great other agencies. I think there's Connecticut Conservatorships that just aren't attorneys, and they do a fine job as well. Now, push comes to shove, some judges will say, you didn't put anybody in proposed. Then they do have a list, because I get files all the time I didn't even know about. They're like, okay, Katrina will take this, or this other attorney will take it, and they run through the list. So you can do it that way as well. So that is really going to be your hurdle, and how to explain it. And again, I'm not all that clinical. I don't do the upfront piece. I very rarely attend an appointment, because they could be all over the place. I just wait until the end. Sometimes I do. Most of mine are virtual, so I'll pop in, and if I have the time, I will sit there for the hearing. But I've been in a lot of rough hearings where the client did not know what a conservatorship was. And in the easiest terms, I'm taking their money and I'm paying their bills.
When a client or case manager wants to get this process started and they want to find the application, is the application something that they could be able to get online? Do they have to go to the courthouse to request it? What does that look like?
So you go to Connecticut Probate Directory, and there's a tab for forms, and it has the forms, and I can list those all out. Like for the petition for voluntary, it's just the PC 301 and the PC 301 CI, which is for their social security, the confidential page. Now, what I tell everybody is to file a fee waiver, or else you're going to pay the application fee. And all my clients generally, I mean, if they had a lot of money, they wouldn't be needing housing, and they wouldn't be needing me. So that's a 184. And basically it just details out their income. And most of them qualify. I mean, I would imagine all of them do. So you always want to file that so they don't incur another fee. The fee waiver also is how they don't pay for me. The state pays for me. And if they didn't file it, the first thing I do is I file one for them. And if you just read through, but those are the documents you want. What's going to happen from there is you'll send it into court. The fee waiver will get granted, and then a hearing will happen, and you'll get notice of the hearing. That's why I always say put your name on it too, because reminders like, hey, you missed this, it just gets dismissed and you start all over again, which doesn't help anybody. Wasting a lot of time, the court's time and all that. And so that's pretty much how that runs.
I think one of the questions that I remember hearing a lot when I was a case manager was like, who can fill out the form? Does it need to be a licensed clinician? Does it need to be, can it just be someone off the street who is working with the person, like an outreach worker or navigator?
It's easy enough to go through. But the client's going to need to be the petitioner and sign the application. But they may need help physically writing it out. So typically you can go online and have it typed as well and have the person sign it. Or you can hand write it out one way or the other. I mean, just because you want to make sure you've gone through every box, you don't want it kicked back out. And I tell people, if you want me to look at it, it takes me 2 seconds to tell you what you missed. But I said, read the instructions. It's pretty easy after you get the hang of it.
So after the person has gone through the hearing and they've been appointed, you, for example, what is that? Or let's say before we even get to that point, because I think this is something that comes up a lot in these conversations, is someone will have a client who is, and I don't want to use the word difficult, but someone who is really against the idea of having their rights taken away, right? They really don't understand the process. They're unsure, but maybe the case manager has had the conversation with them enough times that they're able to get them to the point of where they're like, okay, let's talk about it and see, right? Would someone be able to say, contact your office or communicate with you and be like, hey, my client is like on the fence. I just need someone to explain this to him better than I can because I don't know this very well. Can we set up a meeting with you and you can walk through it with them and the client can ask you questions?
Absolutely. We do it all the time. I've got several this afternoon in the Danbury area just to explain it. And I'm not, telling that with a voluntary, you're not locked in. So say they change their mind and I've been appointed, they simply need to write a letter to court saying, I want to terminate the conservatorship. Automatically in 30 days, no court hearing, it will be terminated because it's voluntary. So that's one of the big things, that they're not locked in. They don't have to go prove anything. There's nothing. That's the difference between the voluntary and the involuntary. So absolutely, you just email me. If I'm not available, I have a staff member. Everybody's well versed to explain what the process is. And a lot of it is around, how am I going to get the money? We explain the TrueLink card, how we do it. It's automatic. And then if we have, we have a good percentage of high maintenance clients who need a bank statement, need to know everything. We give it to them. It's voluntary. They have access to everything that we have access to. We don't do it as a matter of protocol because that would just be a whole nother function, sending out bank statements. And a lot of clients, once it's up and running and it's all set on auto, we don't hear from them because they know what they're getting. They know what's happening. Then we have our ones, we try and do a little bit of savings, and our budget sheets are very clear. So anybody could read it easily to know what's happening and if they're saving. So some, the last week of the month, they'll call and they have to have all that money. We'll give it to them. It's their money. Or if they're saying I'm saving for a trip or a concert, we'll put on the budget, this is what we're saving, and they call for extra money. We're like, hey, you do know you asked us to save money, but again, it's your money. So we will give it to you. After all, our responsibility is to pay all the bills.
Something that you and I had talked about before, was, how you review cases that are coming towards you. I know that in the past, I have experienced where we were trying to get someone conserved and the lawyer that we had approached had said, no, thank you, right? They weren't interested in conserving that person. Whereas your office, my experience, was very willing to just take the client and sort of figure it out as you go. So what does that process look like for you in your office?
So the original files come into me, and I always look at them first and figure out where we're going. I probably make a phone call to a case manager, saying, hey, what's going on with this case, to see where we're at. So I have to see, is this person already receiving Social Security, or is this a brand new application? It goes to two different divisions because processing is different. I just email over to my banker. We open up the bank account. So it's direct deposit on the Social Security rep pay. That starts going to, and once we have that process going, we are also looking at the DSS. So we have a liaison with DSS. We'll create an online account, hopefully, and we become recognized. So we do all the redeterminations because we have everything here. And we review and I'll review the benefits going, are we missing something? Is this person eligible for cash assistance? Even if it's $10, like you want it in case something else goes, or Saga Cash, whatever it is. So we kind of review it and decides, what division are we going here and what needs to be applied for? Or are we just processing? Then the interim, because it takes 1 to 2 months to get the Social Security, is we're, if we don't have a lease yet, we're gathering bills, or a lot of times it's like, okay, finally we have something. We just need that lease. And then boom, it goes to Sabrina to contact the landlord, pay. If you all are doing the security deposit, work with you. And what is the move-in date? My responsibility is that when somebody moves is I have to notify the court. I have to notify Social Security, and I've got to notify DSS. So we take care of all the reporting of everything. The biggest thing I see when I get a case is there's always an overpayment with social SSI because people aren't reporting properly. If you're in the hospital for 30 days, you have to report and your SSI gets turned off, or if you're incarcerated. So we're watching for the discharges to reactivate. So all these little things, but we usually end up with bad reporting. People don't realize the rule. If they have a job, we have to report their payroll. And, that can fluctuate their SSI or not.
So the other question, and there's some questions in the chat that I'm going to get to in just a second, but another question, I know you mentioned leasing up and everything else and clients moving. I think another question that comes up a lot is some folks might feel like they can't get someone conserved unless they're housed due to the complexities of them getting housed, being unstable and everything else. Is that the case, or are you able to work with anyone at any point?
Correct. Any point, I have a lot coming in as homeless.
Right.
A lot. They're either in a respite bed or they're somewhere. So it's homeless. And I have to start the case off with homeless. And again, we have to work with a team. We don't have a housing component that we really work with. We work with the rest of the people all of you who are experts to help us out. We have a lot of our clients call 211. This is where we're at. And then we work together.
And then you, I assume, would be a part of like what your component of the housing process would be really just the financial piece, figuring all of that out.
Right. Getting the lease, paying the bills. The client's going to pick their housing. We're not going to pick it for them. And I mean, as we all know, housing is challenging, very challenging.
Under what circumstance would you say someone would either get discharged from your service or not accepted? Is there anything that you've seen in the past where it's like we wouldn't take somebody because of this reason, or we had to discharge someone because of this egregious issue?
Okay, so we take everybody and we try and work with them, and we're pretty successful. On the discharge part, it's voluntary. If they want to switch to another conservator, we have no skin in the game. That it's fine. Maybe it's a personality. We have a lot of different staffs. We can move them around to different staff members if they're more comfortable. Some don't like to talk to female, male, older, younger. So we have a large staff. And if that's not working, some clients it's time to go. You can resign and have the court appoint somebody else. So there's always that flexibility, and none of us fight it whatsoever.
Right. One of the questions I have here is how do you determine an individual's weekly or monthly necessity money?
Okay, so the way we do the budget, we'll say, for example, on the first, their SSI, so their 943 comes in. From there, we need to know what the rent is, whatever the number is, and then any utilities. If they don't have like a free cell phone, like whatever their bills are, those all get paid out on the first. Whatever is left over, let's say $500, we divide by 4.3, which would cover the whole entire year. And that would be their weekly amount, whatever's left over. And we'd ask the client if you want to save a few dollars here and there for emergencies. And that would go on their TrueLink card weekly, or if they're very good with their money, monthly, to that effect. So it's a budget sheet. So it's very clear. That's what we have left over after the bills. And they're entitled to all their money, or they're entitled to save it up to the $1,600 mark.
Let's see. Not seeing any other questions in the chat. So I'm going to open it up for anyone who has any questions. I'm sure that there may be a lot. So if you have a question, you can either pop it in the chat or raise your hand and we'll try to get through them in an orderly fashion. What if a client wants a family member? Does the family member need certification to be a conservator?
Nope, they do not need certification. There are great videos for training to know what a conservator does. So one of the things is absolutely always want family members if they're going to help them. That is absolutely the least restrictive. What we run into is family members sometimes get burnt out. Most of us we're successor conservators and they're burnt out, or we do with them. So we can kind of, navigate. We have a little bit more resources to support the family member. So we're always happy to be that helps us out a lot. And it sometimes makes the client feel better as well.
Can anybody have a conservator?
Yes.
And do the conservators get paid?
Family does not. And contract conservators get paid at a rate by the state of $90 per month. Yeah, we're not making a lot.
You're doing great work. Let's see. Could we clarify the role of the conservator when a client is transitioning from a group home to independent living?
So we would help with that transition. We work with the two teams. And again, it's a matter of, do we need to apply for different benefits through DSS? You know, so when that's identified and they're moving to independent living, it's fine. The teams, everybody's made that decision. And we just kind of have to do some paperwork. But we always help with the transition and we do all the paperwork.
Question about individuals who have conservator of person only. What authorities or responsibilities would the conservator of person have regarding housing, leasing, etc., if they don't also have a conservator of the estate?
So conservator person, that's a tricky question. We're really, in this form, we're really looking at conservator of the estate. Voluntary conservator person, I do both as well to help with, you know, medical decisions, stuff to that effect. So I'm not sure, you know, housing they can help with. You can't force any. So what I've learned over the years, I can pick housing for everybody and sign a lease. They're not happy.
Mm.
It's a waste of everybody's time. So we have to have them buy in. Does the client like this place? Are they going to be happy there? Or else we know it's just going to be failure. So I know I always get asked, but can't you just make them? And I'm like, no, I can't make anybody do anything. And that's not the way we want to work. It's never going to be successful.
Does the conservator put aside money for clients for funerals, even if they do not want it? And if they do want it, how is it saved, like an escrow?
Okay, so typically we really only look at the funeral contracts because my clients don't have a lot of money. If they're hitting over 1,600, which starts messing with their benefits. So we watch every month to make sure they're under the 1,600. If they're getting up there, our first thing is to, hey, do you need new shoes, boots? Can we buy you anything? Do you want to go out for dinner? You want to spend that money directly. If they want a funeral contract, we certainly will. We have partner with, it's Redgate, but it can be transferred or they can tell us. So there's rules for that. You can only have up to 10,000 now in an irrevocable. But if they want to set that up, we can send money in monthly, or if money accumulates, if the client does not want it, then we got to spend it on something else. So typically they can figure out how to spend it.
What is the process for involuntary conservatorship?
That is very difficult. So it's a different set of forms. You have to get a physician's evaluation. Once you get through those hurdles for an involuntary, when it goes into court, the person will be assigned a court-appointed attorney. And then there will be a hearing, and it will be, the client does not, the client objects, they're going to object. So someone has to present the evidence. Right now, the client's no longer the petitioner. That person becomes a petitioner and has to tell the court why and explain to win their case that this person needs to be involuntarily conserved. And it really depends on the person. And, you know, I have a very big mix. I would say the majority are involuntary.
Very interesting. Let's see. What is the difference between conservator of person and power of attorney when it comes to family?
Okay, so once conservatorship is higher than a power of attorney. Typically that goes away, it's suspended while there's a conservator. So it disappears, it's much higher. Now, power of attorney is least restrictive. We're not going to court. So if they want a power of attorney, that's just a separate document, but that has nothing to do with my office or anything to that effect. If it's working out and that's great, then that's the way to go.
If there are concerns that a family or friend that is appointed the conservator is misappropriating the client's funds, how do you go about reporting that?
You can always write a letter into court. It'll trigger a hearing, and then you'll need to prove it. But A lot of times when I get the involuntary, something has gone wrong. If it's a successor, I'm taking over for a family member, and it happens unfortunately more often than not.
If a client has an income of $1,600 a month and is in shelter with no housing expenses, what happens with their unused funds? I think you kind of talked a little bit about that, but
Right, so we have to get a little creative because they're in a shelter. Maybe we're gonna try and save for a security deposit, but we have to watch this. We have to look at their benefits. If they are SSI, they've got up to 2,000. What happens with the court? That's their asset limit for us to be paid by the state. But they're pretty, if we explain that we're saving for and we're going to do this in an orderly fashion, we might be able to do it. But it could bump them over, and we'd make them aware going, hey, this is what's going to happen. We don't want to get paid. You know, these aren't people with a lot of money. So we have to figure out what we're going to do and how fast we can get them housed.
so in that situation, if someone were to say get close to the $2,000 threshold, is there a mechanism where you would be able to put it into a separate savings account that it would no longer affect their asset? Or is it something that you would have to let the court know, like, we're saving for a security deposit, this is going to go away in a few months?
Right, and we only file our fee waivers once a year, so it's really a timing issue. It may be, that increase for 1 or 2 months, which isn't going to affect. They're still receiving, you can also, they're receiving DSS benefits. That's a factor aside from money that makes them indigent.
What determines someone of being denied voluntary conservatorship?
So basically, if the person walks in and says, heck, I want this, I want a conservator, and I know exactly what it is, they're going to pay my bills and keep me housed, you win. If they walk in and say, I don't want this, the judge is going to say denied right there. It's not an argument, it's voluntary, and they have to want to do this and have to understand easily what it is. Paying bills, benefit, budgeting, and they get canvassed, and they're going to have to answer the question. If the judge does not feel they understand what's happening, they will deny it.
If the client is not receiving their funds from the conservator and the conservator is not responsive, what should be the next steps?
Write a letter to court. And first of all, reach out to the conservator. Make sure you document that. Find out what the issue is. If not, any problems they have, they write a letter to court, and it'll trigger a hearing, and do it sooner than later. But the judge is going to want to know, did anybody try to work this out, or what happened? Where's the breakdown? It happens in every organization. Something goes, there's a hiccup. We had, when Peoples went to M&T, it was the biggest disaster with M&T. We're still trying to clean up the mess. So there were those first couple months, and now we're migrating all the accounts over to a new bank. There's going to be hiccups, but the conservator should be responding to you and explaining. But if you're not getting anywhere, you write a letter to court.
I did see someone's hand get raised before, but it's gone now. So I just want to make sure that I give whoever that was an opportunity to ask a question. If you're still there.
She answered it.
Okay, great.
While she was talking, I thought it, yeah. So.
Got it. Thanks, Sarah. Let's see. What is the conservator's role when a client's mental health jeopardizes their housing?
So this is difficult. If we're only conservator of the estate, what we try to do is hopefully they're connected with services, and we're never getting evictions for non-payment of rent. We're paying the rent. It's for behavioral issues. So what we'll typically do, if their landlord hasn't communicated with the team or with us directly, and they get the famous notice to quit, the first thing we do is it goes over to Attorney Schafler and to me and to Jackie to figure out a solution to most likely have to move them before the eviction goes through. So we'll work with the attorney, we'll work with the landlord. and see if the issue is resolvable. Let's say sometimes, it's a hoarding or cleaning issue. So again, we'll get a cleaning service in there. We're going to have to pay for that, or we can find other resources. If they don't have the money, they need that added support of housekeeping once a week. So we got to kind of look if it's strict behaviors and they're having a crisis, 911 mobile crisis has got to be called. We've done it, even though we're conservator of the estate. If someone's mental health is in jeopardy, you want to make sure that they're safe. But what happens is once they get to the hospital, we're only conservator of estate. So hopefully we're connected with the treatment team. And that's our biggest thing. If they're not connected with services, we try that. We need a team. It's a whole team to keep everybody stable. So, you get these calls, and it's, we need to find new housing now and work it out, no eviction, and we're good to go. We just never want that eviction on the record.
Great. That's the hope that for most of us, to not get that on their record. Let's see. What happens to someone who just got SSDI approval and they either have SSI coming along with an amount that's, sorry. What happens to someone who just got SSDI approval and they have their SSI coming along with a long amount that's due to them, but they are in a spend down situation?
And two different things. So they're still receiving SSI?
Brenda, if you can maybe clarify your question.
Let me try. I think I can try, and let me see if this helps. So a lot of clients are receiving SSI when they should have applied for SSDI, right? Different processes, and we do those processes for them. So your SSI will go away once you're getting the higher amount of SSDI. So that would go away. What happens is sometimes they're still at the same, people don't realize that that's got to go back to Social Security, which is fine. That's easily cleaned up. We're going to see that in real time because we're going to see what came into our bank account. So Social Security has not been sending all the approval letters. Things just pop up into your accounts. We're like, okay, let's redo the budget. Great, they're getting the higher amount. They're finally approved for SSDI because that could take 1 to 2 years sometimes. So you'd only be getting one of the benefits if you're switching over to another one. Now, also with SSDI, if we do get approved, sometimes we get these massive retro payments.
I think that's where they were going with this question.
Okay, I think that's where they were going. So what we do, Social Security allows us a time to do it. TSS doesn't quite get it, but it's fine. So typically this person, how are they living? We probably owe people money. We ask for receipts if that can be provided. And then we start working on the spend down. Sometimes if the retro is really high and we need to preserve the housing and the benefits, and we can pay private pay into it, but we can also do a special needs trust and put that money someplace else. So we look at it, everybody, talk to everybody, make a decision. It goes to my special needs trust attorney. She reviews what kind of trust it's going to be. And then we go to court and we take care of that.
And that becomes an asset for them that they can tap into over time.
Right. And I don't have to be the trustee. Typically I am. So they'll be like, oh, I want, some new clothes. That's something that can be done through the special needs trust. And the trustee can just give the money. We can put it on the TrueLink card, whatever we need to do. So every case becomes unique and the situations kind of keep going. But when it's the same person kind of watching everything and everything's all together, we can work with the team for a solution of what's the best solution for this particular client.
Denise, you had your hand up. Do you still have a question? No, you're good. Okay. Let's see. Clients not receiving. We answered this one already. We saw that one. If a conservator applies for SSI or SSDI and the client is denied, how quickly can the conservator reapply?
We appeal. So we do the appeals and we don't get paid for them. So there's lawyers who do SSDI and SSI and they get paid. That's a whole, we keep looking for a firm to do this for us and they would make the money. we just do them internally now, and we don't keep the retro money. Like, we don't have it's just another whole business. So typically with you appeal, you look through, you're missing medical records. It's usually the medical documentation because you can clearly see the person should be granted. So it's more of a snafu. Medical records. We have someone who just gets medical records, and it's challenging at times. So they may take longer, but if the person should qualify, we're going to get them there.
I think when you and I were speaking earlier today too, you had said that you guys also handle like DSS recertifications and applications and that sort of thing in your office.
Oh yes, we apply for everything, especially like, let's say they're going from independent living to a residential care home. They're going to a little bit higher. We will do the application for cash assistance. We maintain all their benefits. All the redeterminations come in this office. We do them while they'll never have to touch anything. They lose their EBT card. I swear everybody loses their cards. We keep stacks of our TrueLink cards because we can do blank ones. So someone has their money right away. Like literally we keep stacks and we can activate it right away while we're waiting for one with their name on it.
That's great. Erin, you have a question.
Yeah, my question, I guess, is a little, maybe a little more complicated. So say somebody enters into a conservatorship agreement voluntarily. But we've definitely had situations where, yes, people go into it voluntarily. Yes, they have an understanding. Yes, but as time goes on and they maybe aren't getting the money that they typically have access to, a lot of times it's that desire to withdraw because but it is very clear, particularly from a social worker's perspective. Yes, this person entered into this voluntarily, which was obviously the least restrictive mode to go into, but now we are watching them decompensate and make very, very safety threatening, potentially life threatening decisions, withdrawing from conservatorship. Now rent isn't getting paid. Now they aren't getting food. Now that, and so I guess my question is to Attorney Camera, if you are involved with somebody voluntarily as the conservator of person and estate, they submit to the court that they want to withdraw. Has there ever been a case where you felt confident enough that this person really did? Have you ever petitioned to have them involuntarily?
It's a great question. So there's a reason. So let's say they send their letter and the court gets the letter. They want to be released. The court sends out notice to everybody's on the notice list. And there's a reason for the 30-day delay. That gives anybody the opportunity to file the involuntary. And at this date, hopefully there's a treatment team because you're going to need the physical valve, and anybody can petition in that time frame. That's the reason for the 30 days. Mm-hmm. So, and it happens a lot.
And then my question is, with the PC 370, obviously that's what's required for the involuntary conservatorship. So a lot of times I've run into, this doesn't already exist. Unfortunately, yes, we may be involved as social workers, but they may not have this extensive clinical behavioral health team, that has a documentation of their mental health. And I think I've gotten this question answered from our attorneys and probate, but I just want to get your thoughts on it. If we were to petition based on just our concerns, but we don't have this PT 370, if we make a good enough case for our concern, can the probate court then order a physician to examine them or do it? I guess that's where
it's tricky, and every judge is a little bit different. Your case is not going to get thrown out because you do not have the phys-eval, the PC 370. You can testify. Anybody can testify to what's going on. The behaviors, this hospitalization, these are things that are documented, and the court can waive the PC 370 and still order the voluntary. It's up to each judge and how compelling the case is. And
you mean order the involuntary?
Yes.
Okay.
At the PC 370. Now, I just had one where the psychiatrist is refusing to fill out the PC 370. It's part of my review. So I wrote that I'm going to excuse it because this guy won't do it. And the judge is not having this. So we're going back and forth, and finally I'm like, I'm gonna have to subpoena the doctor into court or do something because my review isn't complete. The court needs this PC 370. And the psychiatrist finally caved, but typically, you know, I send them out as part of the review. They fill them out. I mean, we have to chase them a little bit, but you know, they send them back. They know we need this. It needs to be submitted to court. But it's interesting. So, but every judge is different, and it's also what they're hearing in front of them at the time.
Okay, thank you.
You're welcome.
Thanks, Erin. Let me see here. If the client no longer wishes to be conserved, what's the next step? That is to write a letter to the court, correct, and ask to be released.
Correct.
from
And
the
automatically in
conservatorship.
30 days, no court hearing, they'll get a decree. I will get it. I'll do my final accounting, it usually says turn all the money over. So I get the decree, I put everything on their Truling card, do my final accounting. So that's the whole thing, that this is easy, seamless to get out of it. There's nobody fighting it unless somebody comes in with the last question and files an involuntary.
Got it. I think you touched on this a little bit. Brenda had clarified her question. So if someone has a large amount coming in, like 20,000 in retro pay, and they are in a spend down, what happens to the money that's over the 1,600 to be in the bank? And I think you touched on that would go into a special needs trust potentially, or some other mechanism to be able to allow to do that over a period of time.
Correct. Yeah, we'd have to look at what does this client need and what's going to best serve them. Do they owe money to people? Do we buy them a whole bunch of stuff? I mean, this person would be without money for a very extended period of time. You know, how are they surviving? So we have to look at it. And then, are we going to do a special needs trust? Are we not? It depends on the client and their needs. And we can also do a funeral contract, but you know, it's up to 10,000. That's not for me, it's not the best way to spend the money, but we do it all the time.
Got it. And I think you sort of answered this question, but if a client wanted to switch conservators from a family member to an attorney, what would be the first step? I assume that would be contacting the court and requesting
Yep, just write a simple letter. I would like blah, blah, blah. There will be a court hearing and the new conservator would take over. It's voluntary, so they can make those decisions.
Right. Let's see. Has a client ever appointed their conservator through the state as their beneficiary for any insurance policies? And is that okay if a client wants to do that?
The conservator become the benefit? No, absolutely not. 100% no. Wow, no. I hope no one's done that.
What is the time frame once an SSI or SSDI application is denied for the appeal to be submitted before the conservator has to start from the beginning?
That I don't do in my office. Ashley does. And I'm going to go with my gut, at least 60 days. But I mean, there's got to be an extended period of time. And also there's hardship. We were applying for a conservator to help us with this, blah, blah, blah. So I don't know exactly, but I'm assuming most appeals are 60 days.
Okay. I'm not seeing any other questions in the chat or in the Q&A box. If anyone else has any other questions, please let me know. There's one more. Let's see. What happens when the individual died who has the right to take over, for example, returning the apartment keys and vacating the unit?
Okay, so my conserved person dies. Again, we work with the team. Have family members go in or somebody, if there's personal items, and we're trying to wrap it up at this point with the apartment. We'll get somebody to return the keys, and we usually vacate and abandon at that point, but we let the personal belongings get out if they have family members. And then we have to do a final accounting that has to be approved. And then the conservatorship gets, you know, we've got to shut utilities off, whatever it is, we shut down the budget and we have to do it ourselves.
And what happens if they have no family?
We're going to vacate and abandon. I have no interest in personal belongings.
What happens if a person diagnosed with paranoid schizophrenia has signed a quick deed? Should they have been conserved first?
No, you are allowed to sign if you're not conserved. So when you're not conserved, you're just like the rest of us. So whether it was a predatory practice, that's another story. But just because you have a mental health diagnosis, you and not conserved, you can do everything that you want to do, whether it's good or bad. This is how it works.
All right, it is 11:53. We have a few minutes left. If anyone else has any other questions that you would like to ask Katrina before we wrap up for today.
Very well.
All right.
So you'll have my email address, and people always just want to ask me a quick question. Just email me. I answer so many questions from people I don't even know if I know the answer, and it doesn't take me much time. So you want to send out my email.
Yeah, let me grab your email really quick here and post it in the chat. Okay. I think it goes without saying that this was extremely helpful. I hope that all of you that are on today found some benefit in getting your questions answered and finding the benefit in the content that was shared. Again, I will share this with everyone who was registered. So now's your last chance. If you are on here as a different person than you actually are, then please put your email address in the chat just so that I have it. But if you registered directly with your email address, I already have the list of, I think there was 230 people that registered for this today. So you will all get an email with the link for the video, as well as the guidebook that I sent out previously in the announcement. And then everything, if you are joined on our roundtable, you will also see it in the announcements hub when that gets posted. I will make sure to have everything up and available to everybody by early next week. And Katrina's email is in the chat. I will also include that along with any other information that is shared related to this training. Thank you so much, everybody. Thank you, Katrina, for your time today. It is appreciated. And I will see you guys at the next one. Thank you so much.
Take care.